Liz very much. So before we have John come up, I've worked with John a couple of times on these seminars, and have always been impressed with his knowledge and his understanding. I think of him more in the forensic title world when things go wrong. But does anybody know who this guy is?
Vince Lombardi. Chocolate.
No, he's already got it. So Vince Lombardi. Let me tell you why I have this gentleman on the screen. I grew up with 8 kids. There was 8 of us kids. I didn't really end up with the sports gene, but I do remember my father specifically saying about Vince Lombardi when he took over the Green Bay Packers. Remember what he said? He said, "This is a football." And you're going, he said something that everybody, whether they were a rookie or a seasoned veteran, they knew that. But at that point, he was trying to make this sounded down into the hearts of his players. He was going to assume nothing. He made them successful by getting back to the basics. And that is the point of This Is a Football. We're going to be talking about fundamentals, about basics, and title and owner's policy is a fundamental. Now we hear get back to the basics all the time, don't we? Sure, they always tell you. Let me give you a new phrase, because this is really what Vince Lombardi meant with his team. He meant, do the common uncommonly well. That's why you're here today. That's why we brought John, is to help you more than just the fundamentals. Do the common uncommonly well, and you will be successful, as Mr. Vince Lombardi said. So on that note, John, take it away.
Well, thank you, Tim, and thank you, everybody, and thank you for being here, and Tim, thank you for inviting me. And Tim, of course, will be our technical director today. He's the producer, he's the screenwriter, and so forth. And he's also the one who made the mistake of asking me to make this presentation, so he gets the benefit and the blame. And, but anyway, we're here to talk about title policies, and maybe to give you a little better sense of the coverage of the different policy types that are available. And perhaps the most important thing is to help you, maybe help your client select appropriate coverage for their transaction. And so one of the things that Tim has done with this presentation is he's gone global with it. So as we proceed, we'll be getting these tweets in from all over the world. And we have to pay attention to what's up on the board here. And I can see we start off with the owner's policy is limited to covering just the land the buyer is purchasing. So it looks like we got some candy bars. Any thoughts about that?
No.
Okay, so what do we think?
No.
That's right. But there's more to that question than you might think. And the one thing I want to mention is, always take a look at that preliminary report, whether you are representing the buyer or the seller, because there might be information in the report that you need to know about where your seller has something you need to do. And or if it's a buyer, you want to look at that map and make sure it's consistent with what you're looking at on the ground. And one of the things I've seen happen too often through the years is where a seller owns more than one parcel of land and they all join each other. And sometimes they're accidentally selling more land than they intended to sell, and or they may have needed to create some easements for the benefit of the land they're keeping, or reserve some restrictions for the benefit of the land they're keeping. So you want to be especially careful when you have a seller who owns more than the subject property, because you want to have that discussion with them, or which property are we selling? Let's make sure that's what's displayed in the report. Do we have to create any special rights, meaning you might need to have an attorney join your team for that? Those sorts of things. So just never take it for granted that the title company has issued the report on the correct property, especially when there's a seller with multiple properties, and or you need to create some easements. And then the last thing about that too is sometimes we'll have people represent buyers and sellers and they know they're driving across private property to get to the subject property, but yet there's no easements of record that benefit the land. And so if you know you're driving across private property to get to the subject property, and you don't see any easements in the preliminary report which benefit the land, then you might want to ask some questions about that. Make sure that the right interests are being transferred, whether it be the fee to the subject property and or the easements that benefit. So any questions about that? Okay, let's see what's up next. Okay, so know your title policy. So we have 3 policies that are displayed there, and then the question is, these 3 names are Fidelity and First American labels for the same policy with the exact same coverages. There's been some rumors that different title companies issue policies with different coverages. So what do we think? Is that true or false?
Policies are different.
You think the policies are different?
Yes.
Anybody else?
Yes.
Well, which policies are different?
All 3 of them.
Oh yes, these are, that is correct. So this policy is different from this policy, which is different from this policy. But is the standard policy that First American issues, is it the same as the Fidelity policy or the Chicago policy? Is the homeowners policy the same with all the different title companies, the coverages?
First American just gives the Eagle policy now, I think, routinely.
They call it the Eagle policy, and what we want you to know, though, is despite that, the coverages, the industry issues are the same. So when you choose your title company and your escrow company, you don't have to worry about the coverages being more or less somewhere else. They use the same forms. They have different names, and that's sometimes a source of confusion. We don't want you to be confused about the policy based on the company you're working with. So you can choose your company based on the level of service they provide to you and the way they problem solve and so forth. But you don't have to choose a company based on what you might believe one company issuing some coverages that the other companies do not issue. So are there any questions about that? Yes?
What about when we have to work with an out-of-town Sacramento company? Would be the same?
Yes. Yes, and yeah, and I'll give you a little more information about that too. Basically, the reason why the forms are the same is when the title industry got started in the 1870s, and we're not going to cover the time period from 1870 to present, each of the companies were issuing their own types of coverage, and they would vary it from transaction to transaction. And they would issue these coverages usually to attorneys representing one of the principals, and or a lender would be involved. And lenders and attorneys got tired of negotiating on a policy-by-policy basis. And as you picture people moving west now through the decades, eventually out to California, and especially after World War II, you can imagine how the money was coming from the East Coast to fund these purchases. The lenders wanted a form that they would recognize and that they were used to and that they understood. And there's 2 trade organizations in California. One's called the California Land Title Association. Then you have the American Land Title Association. And since most of the funding was coming from back east in the mid-50s through even the late 60s, lenders were familiar with the American Land Title Association forms. They weren't familiar with the California Land Title Association forms because the lenders were coming out of the East Coast. So they always required this American Land Title Association form, which we used initials ALTA, and they wanted certain coverages. And title insurers can take extra risk with lenders than they can with buyers, because for a lender to have a claim, they'd have to foreclose, they'd have to put the property on the market and discover a problem. That's never going to happen, right? And so they took additional risks, and the lenders wanted to make sure that they wouldn't suffer losses from unrecorded easements and violations of CC&Rs. So the coverage for the lender was a little greater than the coverage that would be for the purchaser of a property in California using the California form. So people came up with the idea that ALTA meant more coverage than CLTA, and that's not true. You can have ALTA extended coverage or standard coverage. You can have CLTA extended coverage or standard coverage. So I just want you all to know that CLTA and ALTA stand for the names of the trade organizations. And what's happening now is more and more of the forms we're using in California are American Land Title Association forms, and or the form has been approved by both associations. So we have forms that are both ALTA and CLTA approved. And so I just thought I'd answer that. So throughout California, we use our California forms, unless someone is, asking for the American Land Title Association form. You'll see typically if there's a firm in Century City or Beverly Hills representing a buyer, they'll want ALTA extended coverage often. Commercial transactions, they want that. But you can create a CLTA extended form as well as an ALTA. But anyway, to answer your questions, the forms are uniform because it helps eliminate confusion. And the way you modify your form is you can modify by virtue of issuing endorsements. And you can issue endorsements to expand your coverage, and you can even issue endorsements to contract your coverage. So does that help a little bit with your perspective? Yes,
So
Al?
what are the differences or benefits of having an extended owner's policy? What is extended?
It would be so nice to have a visual. Sometimes it's easy. Oh, so there's a little house. So what do we know? That doesn't tell us much, does it? Let's see what happens.
It's not gonna stay
Oh,
long.
standard coverage. Okay, so that house is completely covered with standard coverage. Is there something else to offer? Oh, we have. So this is suggesting maybe that there's a bigger area of coverage of the homeowner's policy. And and then there's well, there you have it. Okay, we better talk about these then. Yes, you're right, Al. There's different policies.
Expanded or extended? We're changing
Extended.
words.
Oh, I'm sorry. Well, that expanded, it looks like expanded, it's really a secret code for extended. So that is, you're absolutely, we can't fool Al. He's a volleyball player, and volleyball players are special. And so it's ALTA extended owner's policy is what that really says. And, but anyway, so yes, there's quite a difference. And we'll start off with just a little bit about standings. We really want to talk perhaps mostly about the homeowner's policy, and then we'll conclude with the extended. The standard's a good policy, and that's the policy that was developed originally in California, and there's a lot more there than people realize. And the basic plain vanilla of the standard coverage is that it will identify who the owner is, it assures them that they own the land, and that says a lot. One of the interesting things is the standard coverage policy has 4 coverages. And when you look at the next step, which we'll look at in a moment, if we look at what's called the homeowner's policy, that has 32 coverages. But part of that is, someone who didn't study for the test and they start throwing in a lot of extra stuff to make it sound like they know what they're saying and it's just fluff. And I'm not saying the homeowner's policy is fluff, but what they've done is, instead of assuring the owner that you own the property, which means that you're covered against pre-existing forgery, you're covered against pre-existing irregularities in court proceedings, you're covered against impersonation, all sorts of things that may have happened beforehand, forgery. What they do in the homeowner's policy is they go, we provide coverage for forgery, prior to taking title. We provide coverage for if you lose title because someone impersonated somebody else. So what they've done is they've listed all the things and spelled them out. So again, it's akin to, you can say to your child that you want them to come straight home from school, and that's it. Or you can say, I want you to come straight home from school, but don't stop at Sally's, don't stop and pet the neighbor's dog, don't stop at the toy store. In other words, you're spelling it out, and that's one of the reasons why you have 32 coverages in the homeowner's policy, because they spell everything out. But despite all that, the homeowners will provide you more coverage. So the standard coverage provides you with the most important thing: you own the property, they describe the property that you have an interest in, they explain it's subject to exclusions and exceptions, and then they list exceptions in Schedule B. The one thing that a standard policy will not do is protect you against matters that are unrecorded matters. So if someone has an unrecorded easement that passes beneath their house, you won't be covered for that. Or if there's tenants in possession and some unrecorded leases, you won't be covered for that. So the big thing that a standard will not do is provide you with matters pertaining to rights in the property stemming from unrecorded documents. That's the big thing. And then it also will not offer you protection against matters that a survey would disclose. So if the neighbor's house encroaches on your boundary lines without a survey, there's no protection against that. So there's certain risks involved, but for the most part, the standard coverage is sufficient. And it can always be expanded to offer more coverage. Let's move on to the next, which will be the homeowner's policy. But you probably heard me say, because this is sort of an important distinction, is the policy will offer you assurances that you own the property and they identify it, but it'll be subject to exceptions and exclusions. Is there a difference between exclusions and exceptions? Anybody think there might be, or could be, or are you curious as to why there's exclusions and exceptions? There is a difference. And what an exclusion is something that was never intended to have been covered by the title policy, but they're just trying to make sure that you know that. So, for example, matters that would not affect real property would be matters such as governmental regulations, eminent domain.